Today we are starting on Chapter 5, which is looking at ethics regarding judges and lawyers. Researchers have identified some aspects of the early practice of law in Virginia and Massachusetts. In Virginia, the planters class believed that the law was a function to support the existing social structure. In the early days of the colony of Massachusetts, natural law was applied in the form of scripture as well as imported law. It was not until the mid-18th century in the colonies that the legal professions began to gain general acceptance, but its size remained small. With the greater acceptance in securities, lawyers began to develop a professional identity and to become a self-conscious professional group. This led the profession to address matters such as professional conduct and ethics, and a county bar association that was generally voluntary in nature began to create ethical rules. Between the American Revolution and the Civil War, the practice of law grew rapidly. During the early 19th century, the public appeared hostile towards lawyers, an attitude fueled partly by their role as post-war debt collectors. Legislated codes of professional conduct existed, but they were short and vague. In 1870, the Professional Bar Association of New York City was founded, and in 1878, the American Bar Association, the ABA, was established. With these institutions came comprehensive bar associations that attempted to control the practice of law. In 1908, the ABA accepted a draft of Canons of Professional Ethics inspired by an essay of professional ethics that was written by George Wood. Wood insisted lawyers' primary responsibility was to their clients and argued that social unity was not a factor that should concern lawyers in any cases that they argue. In the 1960s, some lawyers began to argue in favor of a public interest law and against too great a concern of making money. In 1969, the ABA replaced the canons with a new code of professional responsibility that specified ethical considerations for all attorneys. Professional ethics is an expression that has a multitude of possible meanings, and it is frequently used to signify rules governing professionals and professions. Trust is an aspect of professionalism, and the encouragement of trust has become a fundamental characteristic in professional relationships because clients depend on the superior knowledge of the professional. Lawyers tend to see their role in securing justice as an important contribution towards establishing an efficient law system that supports law as an institution and as promoting procedural justice. These objectives are derived from the adversarial system that equates justice with the protection of rights. In the adversarial system, the decision maker or judge adopts a passive role, listens to the arguments from both sides, and makes a decision based on the evidence and the arguments that are presented. Lawyers may exercise virtue of their relationship with clients, but in pursuing their clients' interests, they may engage in practices that could be considered unfair, uncooperative, or selfish, acts that would be considered to be virtuous. Once it is accepted that lawyers seek justice in terms of defining the rights of an individual, the lawyer's role in society becomes one of giving citizens right to vigorous representation, and the commitment is embodied in codes of conduct and ethics. In the terms of ethics, therefore, the Anglo-American criminal adversarial system has the effect of putting the interests of the client above all other considerations, including the general societal good. The principle of neutrality requires that lawyers adopt a neutral stance in relation to their clients or causes, and that they defend causes that may personally be found morally repugnant. The principle of neutrality is seen as supporting the notion of equality before the law, and it is itself considered a social good. Arguably, the effect is to narrow the number of moral choices that a lawyer may face, because lawyers will make moral choices based on the duty owed to their clients and on their need to remain neutral in relation to a client's cause. There may be circumstances that are so offensive to the lawyer's sense of morality that the lawyer may decline to represent a client, and this is called a conscious objection. The most fundamental expression of legal ethics is that a client's interest should be taking precedence over that of an attorney. Is a lawyer required to accept any client who approaches him or her for assistance? In the United States, there's an obligation to accept particular clients or types of clients based on an ABA Model Rule 1.2, which requires that legal representation should not be denied to those who are unable to afford legal services, whose cause is controversial, or who are subjected to popular disapproval. A comment to Rule 6.2 adopts a flexible approach by stating that a lawyer is not ordinarily obligated to accept a client whose character or cause the lawyer regards as repugnant. A lawyer has a pro bono responsibility under Rule 6.1 that can be met by accepting a fair share of unpopular matters or by taking an unpopular or an indigent client. When does the lawyer-client relationship end? Per the ABA Model Rule 1.16, this allows lawyers to withdraw their representation if a client insists upon pursuing an objection that the lawyer considers to be repugnant or imprudent. Sometimes it may be difficult to determine when the lawyer-client relationship has ended, and in some situations, duties towards clients, such as confidentiality or avoiding conflicts of interest, will continue even if there is no active relationship. Can a defendant be required to accept a lawyer in a criminal case? The Supreme Court ruled in Ferrita v. California that even in a serious criminal case, a defendant cannot be forced to be represented by counsel. The court did argue that the right to defend is personal and that a defendant will bear the personal consequences of a conviction. The lawyer and the state will not. Confidentiality. Keeping the affairs of a client confidential is a fundamental ethical duty imposed by attorneys. Confidentiality represents a respect for privacy, and in practical terms, clients will be reluctant to consult an attorney who is known to gossip about their affairs. This confidentiality belongs to the client and not to the lawyer, and thus only the client can waive it. Some doubt the concept of confidentiality between a lawyer and a client, arguing that the ethical rules related to the practice of law should not protect the guilty client over an innocent third party. However, the arguments favoring limiting confidentiality necessarily lead to the conclusion that clients will not disclose information for fear of it being revealed, or it might prevent a zealous defense. The general duty of confidentiality to a client should not be confused with a lawyer-client privilege. The latter is a principle of evidence relating to revealing information during a trial, and it provides that client confided that their confidences are revealed by an attorney may not be used against them as evidence. The duty of confidentiality is broader because it requires a lawyer to keep the client's confidence generally, whereas the privilege relates only to the confidence being used as evidence. When it comes to client perjury, a question that we look at is, what should a lawyer do when a client commits perjury or makes it clear that they are intending to commit perjury? Monroe Friedman argues that the first duty of an attorney is to try and persuade the client not to commit perjury, but if the lawyer cannot persuade the client, the lawyer should present the testimony as if it were true. He contends that imposing a duty of the lawyer to divulge perjury would involve the lawyer in a situation of inconsistent obligations. Until the mid-1980s, the law on this ethical issue was unclear, but courts generally held that in a civil case, a lawyer who is aware that a client has committed perjury must disclose it to the court if the client refuses to do so. However, in criminal cases, there are added constitutional dimensions that produce more complexity. The argument being that informing of one's own client is such a grave violation of the confidentiality rule, it could be considered unconstitutional. Model Rule 3.3 requires that lawyers take reasonable remedial measures when they come to know that evidence is false, and this duty applies even if it involves the disclosure of confidential information. Lawyer-client confidentiality is completely negated if the client consults the lawyer in a furtherance of a crime or a fraud. Where this exception applies is information that would otherwise have been privileged must be disclosed when a proper demand is made. Model Rule 1.6b1 allows a lawyer in certain narrowly defined circumstances to disclose confidential client information to prevent further harm. This exception applies to crimes that have yet to be committed, and it should be contrasted with completely past crimes for which disclosed client information is not permitted. So an example for this would be if a client is planning to commit a future crime to, say, prevent a witness from testifying or do harm to a witness. This is something that an attorney would have to disclose to law enforcement to prevent future crimes from happening or violence towards that individual. The two main systems under which lawyers represent clients in the West are adversarial and inquisitorial. In an adversarial system of the law, the parties and their lawyers play the principal role of gathering the evidence and examining witnesses in court, and the court plays a less active role. In the inquisitorial system, the court plays the main role in gathering the evidence and questioning witnesses. There are 6 reasons commonly argued in favor of an adversarial system. It is the best system for discovering the truth. It is the best way of defending the rights of the client. The nature of the lawyer-client relationship is intrinsically good. It prevents abuse through a checks and balance system. It honors human dignity. And it is so embedded in the social fabric that adopting another system would be too disruptive. According to Model Rule 1.3, a lawyer is to act with reasonable diligence and promptness in representing a client. The comment to this rule made it clear that the lawyer is expected to use zeal, commitment, and dedication, and that the zeal is an appropriate method in litigation. It has been suggested that criminal defense lawyers may run into conflict with the commitment that a lawyer must see the utmost zeal and dedication in representing clients. An example of a potential conflict came from the field of so-called impact litigation, when lawyers select certain cases to raise certain issues. Is it ethically proper to represent a client accused of a criminal offense when the lawyer knows that the client is guilty? Is it ethically proper to cross-examine a witness with the aim of discrediting the witness' credibility or reliability when the lawyer knows that the witness is telling the truth? Is it ethically proper to have a witness give testimony when the lawyer knows that the witness will commit perjury? In their role as protectors of the state and the public, prosecutors act in an adversarial capacity which requires zealous advocacy. Prosecutors are supposed to represent the public interest, but they may also see themselves as accountable to the police and to the victims. Unlike other lawyers, prosecutors, in their representation of the public, in effect, make their decisions without the assistance of a client. At least since 1935, when the Supreme Court decided Berger versus United States, it has become the law that for prosecutors, winning is not everything. According to the Supreme Court, the primary duty of a prosecutor is to seek that justice is done. The prosecutor must seek justice, not merely to convict. In performing the function of achieving justice, the prosecutor must assist the court in arriving at the truth fairly. Model Rule 3.8 sets out the general duties for a prosecutor in a criminal case, which are designed to ensure that an accused receives a fair trial, specifically a prosecutor. A prosecutor is not to prosecute a charge unless it is supported by probable cause. They must make a reasonable effort to ensure that the accused has been advised of their rights to obtain counsel and has been given a reasonable opportunity to do so. They must not seek to secure for an unrepresentative defendant to waive any important pretrial rights, such as a right to a preliminary hearing. They must make time to disclose to the defense all of the evidence or information that the prosecutor is aware of, and this tends to negate the guilt of the accused or to mitigate the offense. And with respect to sentencing, they must disclose to the defense and to the court all mitigating information known to the prosecutor unless the court is going to direct them to do something otherwise. In terms of the administration of the criminal justice, ABA standards state that the prosecutors are administrators of justice and advocates and officers of the court, and they must exercise sound discretion in the performance of all of their functions. The prosecutor has broad discretion over bringing charges. This charging decision is protected by almost absolute immunity. It is arguable that the probable cause standard adopted in Rule 3.8 is an insufficient determinant against prosecutorial abuse because a violation of that rule can generally be found only in instances in which a prosecutor must have known that they lacked probable cause. A better basic than knowledge may be a reasonable belief in that the presence of probable cause, that is, whether a prosecutor can show that they are carefully considering the issue and formed a reasonable belief that a conviction would be secured. Sometimes prosecutors elect not to enforce a particular statute or follow a policy of non-prosecution. Prosecutors sometimes also announce that they will not enforce proposed laws in the future in an attempt to influence a local legislature. The ABA suggests that in deciding whether to bring charges, the criteria to be considered should include a prosecutor's assumption of guilt, the harm caused by the offense, the disproportion of the punishment to the offense, the possibility of improper motives for a complaint, an extended non-enforcement of a statute where the community accepts that non-enforcement, the reluctance of a victim to testify, the cooperation of the accused in the arrest or conviction of others, and the possibility of prosecution by another jurisdiction. When statutory checks exist on the discretion, what statutory checks exist on the discretion of the prosecutor? In many states, the indictment process requires a grand jury to determine if there is sufficient evidence to support allegations against the accused. In determining probable cause, a lay grand jury tests the prosecutor's charges by offering a common sense view. In law, the grand jury is empowered to refuse to approve an indictment and is therefore said to be the check on the prosecutor's power of that charge. However, in practice, the grand jury is regarded as the mechanism for the routine endorsement of a charge. Several reasons support this critique. The prosecutor acts as an advocate for the state and is a legal advisor to the grand jury. Sessions are conducted in private and defense lawyers are not permitted to be present. The normal rules of evidence do not apply, and in reality, grand juries only rarely refuse to return an indictment. Rule 3.8 requires disclosure of evidence to the defense, and this is broader than the Brady Rule on which it was based. The ABA Standing Committee on Ethics and Professional Responsibility, in a formal opinion on Rule 3.8, has noted, courts as well as commentators have recognized that the ethical obligation is more demanding than the constitutional obligation. The prosecutor's constitutional duty to make voluntary disclosure of the evidence to the defense is set in Brady v. Maryland and subsequent cases. In considering this constitutional duty, the courts determined that a conviction can be overturned based on the prosecutor's failure to provide evidence. This constitutional rule takes account for other factors, such as the significance of evidence and whether the defense made a proper request for it. In a number of ways, the pretrial disclosure standard remains imprecise. The ABA standard is higher than that imposed by the Constitution, and the ABA has stated that the rule requires disclosure before the entry of a guilty plea. When a prosecutor violates Rule 3.8, they are liable to be disbarred. After charging but before trial, the prosecutor must begin negotiating with the defense to arrive at a plea bargain. The aim is to achieve a compromise by reducing the charges against the defendant or securing a reduced sentence in exchange for a guilty plea. The Supreme Court ruled plea bargaining is constitutional under Brady v. the United States in 1970. Plea bargaining is not supported by the public, even though it disposes approximately 95% of all of our criminal cases. Proponents of plea bargaining argue that it facilitates case processing, promotes convictions where guilt is clear, and it enables a prosecutor to customize the appropriate punishment. Critics of the practice argue that it is coercive and contributes to false pleas of guilt or a wrongful conviction. Overcharging. In relation to plea discussions, ABA Standard 3-4.1 states that it is unprofessional conduct for a prosecutor knowingly to make a false statement or representation in the case of a plea discussion. In spite of the moral force of these standards, a prosecutor may deliberately overcharge a defendant as a plea bargaining tactic. Although some may see a plea bargain being beneficial to the defendant, in fact, a plea bargain benefits the prosecutor because a guilty plea saves many hours of the prosecutor's time and, in eliminating the expense and time of a trial, prevents the criminal justice system from becoming overloaded. As long ago as 1920 to 1930, crime surveys documented the dependency of the criminal justice system on plea bargaining. In discussing the negotiated plea, Kempness points out that both sides have bargaining powers. The prosecutors may be burdened with conducting many cases, and perhaps in some there is insufficient evidence for them to secure a conviction. The prosecutor is under an administrative and political pressure to complete cases and to secure convictions. On the defense side, a number of factors may influence a defendant to accept a guilty plea. Plea bargains are required to be voluntary. However, the question of whether duress has been applied can be problematic. The Federal Rules of Criminal Procedures require that the court to satisfy that a plea of guilty is voluntary through addressing the defendant's personality in open court, determining that the plea is voluntary and not the result of force or promise apart from the plea agreement. The essence of plea bargaining is that a defendant must make a hard choice between something certain and something uncertain, and even when the defendant is innocent and the prosecution's case is weak, the defendant may accept the plea bargain for its certainty rather than taking the chance on what might happen at a trial. Plea bargaining's adversary effects are its coercion on a criminal defendant, the acceptance of a measure of punishment less than the consistent with a guilty plea, and the relaxation of the standards of a conviction. Criticisms of a plea bargain. Some innocent people may be induced to plead guilty by promises of a lenient sentence. Plea bargaining results in excessive leniency. It is impossible to control. It shifts sentencing policies from the judge and legislatures to the prosecutor, and in doing so, it blurs the distinction between guilt and proper punishment. What would be the effect of a ban on plea bargaining? The effect of a ban on plea bargaining in Alaska were that the court processes did not become overloaded and that defendants seemed to plead guilty at the same rate and that there was little change in the conviction rate. In one view, the practice is unfair because it determines a defendant's guilt without an investigation, evidence, or fact-finding by an impartial body and may adversarially affect a poor or unsophisticated individual. Lawyers' caseloads may be a major reason for this practice, and neither prosecutors nor defense attorneys want to try criminal cases. The political aspect of plea bargaining is that an elected district attorney is concerned with securing a high conviction rate, maintaining their good relationship with private lawyers of influence in the community, and avoiding the loss of high-profile trials. One consequence of plea bargaining is the absence of a public trial that shows accountability and condemnation. Some argue that ABA ethical standards are inadequate in ensuring that the ethical duty of a prosecutor is upheld. The prosecutor's decision about whether to investigate a suspected crime is not the subject of any code or professional responsibility, even though the prosecutor's motives in conducting an investigation might be open to question. Elective prosecution based on improper motives is an abuse of official power and a violation of the fundamental rights and constitutes unethical conduct. New York proposed to enact a law to establish a commission for prosecutor conduct. The proposed commission was empowered to recommend to the governor for a prosecutor to be removed from office or to retire, and could itself admonish or censor a prosecutioner for their misconduct. The legislation was strongly opposed by the New York District Attorneys Association, which challenged its constitutionality. In January 2020, the bill created the law was ruled unconstitutional on the grounds that the Commission unconstitutionally altered the separation of power by changing the authority empowered to discipline an attorney. There have been numerous cases that have been reported of prosecutor misconduct, some of which have resulted from overzealousness in seeking a conviction, but most of which involve issues such as conflict of interest, failure to enforce the law, and filing charges vindictively. The Center of Public Integrity in Texas identified approximately 600 appeals cases in the state of Texas between 1970 and 2003 in which defendants raised allegations of prosecutor misconduct. Out of the 185 cases that were exonerated since 1973 that were based on DNA evidence, misconduct by police, prosecutors, and other government officials, this has played a role in approximately 69.2% of those cases. In considering the issue of why misconduct occurs, one suggestion is that the reason lies in the successes, and that if a prosecution is prepared to take an ethical risk in an argument, they do so because they believe that the approach would be effective. When prosecutors are faced with a difficult case, they might be tempted to influence the jury to decide in favor of a conviction by prefacing a matter that might be highly prejudicial. The jury is likely to place great confidence and trust in a prosecutor, so familiar types of misleading conduct do include the following: attempts to place in the jury's mind innuendos that is damaging or prejudicial to the defendant, allusions to expert testimony that will cast doubt on a defense witness credibility, an attempt to enhance a witness's credibility by referring to that witness's willingness to take a polygraph test, and comments and questions that suggest that a defendant's reliance on a constitutional right establishes evidence of guilt. Another form of prosecutorial misconduct involves the prosecution attempting to intimidate or improperly influence a key witness or witnesses. The practice of deferring sentencing, in which the prosecutor delays the sentencing of a witness who has pled guilty but will not be sentenced until after they give testimony against another defendant, in a way is satisfactory to the prosecution, but it is also condemned. Another common form of witness coercion involves the use of prior convictions to impeach a defendant or a defense witness in an instance where the prejudicial effect on the jury outweighs the attempt to cast doubt or credibility. Prosecutorial misconduct continues to exist because of the absence of inadequacy of penalties imposed on the prosecutor for such misconduct. For prosecutors, the endorsement of conviction affirmed is appellated opinion is more important than the condonement of a prosecutor's misconduct. Explanations for prosecutorial misconduct include the notion that a prosecutor is aiming to secure justice and, believing most defendants are guilty, feel compelled to avoid their problems that might render a not guilty verdict. Some commentators also suggest that the Supreme Court has been reluctant to control prosecutorial misconduct. Generally, in cases of a prosecutor's misbehavior, the court will excuse the misbehavior by applying arguments of fundamental fairness or a harmless error. The State Bar Association and disciplinary bodies are empowered to sanction a prosecutor's misconduct, but they don't do so very frequently. Some prosecutors' offices have taken the responsibility themselves for evaluating their own policies and practices to prevent mistakes and misconduct. They have created their own internal program that includes incentives such as best practices or committees that are formed for best practices and a conviction integrity unit. The Best Practices Committee operate at a state level for all prosecutors and their offices within that state. They will discuss criminal justice policies and practices and will share information and some review ethical issues. Rule 3.8 forbids a prosecutor from making any specific comments or statements out of court that might be prejudicial in a criminal trial. The rule includes an exception for necessary statements that are directed towards public information and for the legitimate purposes of law enforcement. Considering the close relationship between police and prosecutors, there is a conflict of interest in excessive force cases. The interest that prosecutors have in maintaining good relationships generally with local police include the particular need for them to secure their cooperation in a pending case that could lead them to refrain from indicting an officer in an excessive force case. This possibility could constitute a serious ethical violation and could be avoided by appointing a special prosecutor to consider a police prosecution as a means to maintain public confidence in the justice system. Police and prosecutors inevitably work together on criminal cases. When police are brought to trial, they benefit from their status as members of law enforcement, and studies have identified several trends in prosecution of police officers. Prosecutors are reluctant to bring charges against police and often decline to do so. Reluctance to charge police reflects the special protection that police tend to have and they will receive in an investigation process. Prosecutors can, in effect, control the grand jury process and might be regarded as using the process to avoid public scrutiny. Officers can be prosecuted, but it usually depends on being regarded as credible by judges and juries, whereas people who suffer a police brutality or worse often have criminal records and face mental health or addiction challenges that adversarially will affect their credibility. Even when they are convicted, police may receive a lesser sentence as compared to those in the general public. Police must be competent and ethical, and their actions must also promote respect for their decision. Judges have considered power and authority over individuals, and they exercise substantial discretion when acting judicially. They are expected to conduct themselves according to a high standard of professional conduct, and they are held to a higher standard of law than lawyers and other persons who are not invested in the public trust. These stricter concerning judges and judicial conduct are reflected in the Code of Judicial Conduct of the American Bar Association. A model code of judicial conduct was adopted by the ABA in 1990, and it establishes standards for ethical conduct by judges. The ABA warns that the code is not intended as an exhaustive guide for the conduct of judges, but it is intended to state basic standards that will govern judicial conduct and provide a guidance to assist judges in maintaining a high level of personal or judicial behavior. Some of the most important canons of this code are related to impartiality and bias. Judges must also be faithful to the law. They must not sway by a partisan interest, public clamor, or fear of criticism, and they must be patient, dignified, and courteous of those who they are dealing with. While all federal judges must adhere to the Code of Conduct, the justices of the Supreme Court are not bound by such a code. One significant aspect of the U.S. judicial system is the election of judges, sometimes through a partisan election. This raises questions about the influences that elected judges may be subjected to in performing their judicial duties. When an election is nonpartisan, the candidates' political party affiliations do not appear on a ballot. In states that use a partisan election, judicial candidates are usually nominated in primaries or conventions or through a nomination petition. The proponents of partisan elections for judge argue that judges are policymakers and should therefore be directly chosen by and be accountable to the people who are affected by those policies. That a partisan election is an open method of selection, and that identifying a potential judge's political affiliation will give voters an indication of their political ideology. Those who argue against a partisan judicial election contend that voters generally have no knowledge of the candidate's qualifications and in an event are not competent to assess the qualifications. Nominees are selected by political leaders based on political grounds rather than merit. Successful candidates are likely to feel obligated to the political leaders who select them and to those who contribute to their campaign funds. Many otherwise qualified candidates are deterred from seeking office because they are required to conduct professional campaigns. Voters have a tendency to be influenced by non-judicial qualifications, such as a political affiliation, and having to periodically seek re-election will discourage many potential worthwhile candidates. To what extent do judges take ideological approaches in their judging? One study of judges in a superior court in Arizona found that judges presented themselves as mere implementers of the law, divorced from their politics and social backgrounds, despite that they were required to be significantly involved in a local political process to become a judge. Judges who take a procedural-oriented stance on the due process represent a politically liberal approach to the role of the state in relation to an individual. Judges who take a record-oriented stance follow a political conservative notion of the role of the state in relation to the individuals. The conservative view see the state as attempting to minimize interference in the lives of individuals, whereas the liberal view consider the state as a protector of human liberties. The study, along with the systems of political appointment and partisan election of judges, raised the issue of the linkage between political ideology and judicial performance, especially in relation to the ethical duty of a judge to make a non-political, unbiased decision. As well as acting without prejudice or bias, judges are expected to disqualify themselves in any proceedings in which their impartiality might be questioned. In terms of a judge's personal life, under Canon 4, personal activities are categorized as extrajudicial activities, and judges are required to minimize the risk of conflict between those activities and their obligation as a judge. In financial activities, judges are not to engage in financial or business dealings that may be seen as exploiting their position as judges, or to become involved in a transaction or business relationship with lawyers or other persons likely to come before the court. Canon 3 prohibits judges from commending or criticizing jurors for their verdict. The advent of social media has posed new challenges for judicial ethics, and judges have received guidance from their state bar and from the ABA on ethically navigating social media issues, such as judges should not comment on pending cases on social media, and all comments on social media should be treated as public comment. Judges should not conduct independent investigations on social media. They should carefully guard their language on social media as to not be revealed as bias or prejudice. Judges should monitor comments on their social media pages because some opinions assert that judges are responsible for the content posted by others. Judges should avoid expressing a like if there is likely to be a suggestion that they are furthering personal or economic interests of others or publicly endorsing a candidate of a public office. Some opinions prohibit a judge from friending lawyers who may appear before the court. Others do not prohibit this but warn against creating an appearance of impropriety by friending particular persons or a category of persons. Application of virtue ethics to judges. Certain virtues have been identified as being relevant to the social role of a judge. Incorruptibility, sobriety, courage, good temper, impartiality, diligence, and carefulness. These virtues, which have been referred to as uncontested judicial virtues, are widely expected assumptions about what constitutes good judging, and ought to be applied when federal judges are selected instead of focusing on their views on a social issue.